Southwestern Transport at 18-wheelers. It covers everybody.
So it's not limited to just 18-wheelers?
It's not.
It applies.
Present to fix this moving forward.
Young, on bear as registered for the bill but not wishing to testify. Is Ron Bear here? Okay. The chair will show Ron Bear as registered for the bill, but not wishing to testify. Chair calls Craig Island, Laura Temez, Jim Perdue, and Jack Walker. Laura, we'll start with you if we can. Got you here. Laura Temez on behalf of Texas Trial Lawyers registered against the bill. Is that correct?
Yes, thank you, Mr. Chairman. I'm Laura.
It's the Texas Trial Lawyers Association, correct?
Correct.
So do I have your permission to change the record to Laura Temez testifying on behalf of the Texas Trial Lawyers Association against the bill?
Yes.
Okay, thank you.
Yes, Laura Temez. I former president of Texas Trial Lawyers Association. I was vice president in 2021 and am familiar with the negotiations that were ongoing. First, I want to start out by saying that the families who are going to tell their stories today are not reflective of lawsuit abuse. We are all against it because it hurts the good cases. But I do want to set the record straight on a couple of things. I try these cases. I tried one under Chapter 72. Though my colleagues here also try cases in this universe, and we have made 72 work. But I want to clarify one thing that has been said, not only in the Senate, but here, that the admission rule, or the Patterson rule as we know it in Texas, has been the law of this state since 1961. That is not how we have been trying cases in the 14 appellate court districts. In fact, about 8 months after this law was enacted, TLR filed a brief at the Supreme Court in the FTA's case, and they said, this court, however, has not explicitly adopted the Patterson rule as the law of the state. In the present case, this court can and should explicitly confirm the Patterson rule. So what was the law? Because Patterson case was a Beaumont Court of Appeals case, not a Texas Supreme Court case, from 1961. 1972, this state became a comparative fault state where everybody's before the jury, from the victim to the defendant to the company, everybody. What ends up happening in 1985 is this legislative body codified Chapter 33.003 that mandated that a juror shall, or a jury shall, look at everyone's responsibility as to the cause of the crash. In 2003, responsible third party, which TLR were proponents of, said even if they're not technically responsible for the crash, if they in any way caused or contributed to the crash, they will be on the jury charge. A phantom vehicle can be on the jury charge. Somebody says, I didn't see that car coming, and they braked. Workers' comp barred company can be on the jury charge. So that's how we were operating, because there was a conflict of authority. And I know my time is up, Mr. Chairman. I just want to finish this thought. Thank you. There was a conflict in authority in the appellate courts between Fort Worth and Dallas. That preceded 2021, Chapter 72. So how are we handling that conflict? Because some in Fort Worth, they were putting the trucking company on the charge. In Dallas, they were putting the trucking company on the charge. In Fort Worth, they were not putting the trucking company on the charge. So that conflict in authority created all these appellate courts saying, well, am I going to follow Fort Worth or am I going to follow Dallas? Because the Texas Supreme Court had not effectively adopted the Patterson rule. So we were submitting it both ways. Chapter 72 cleared up that conflict. And so because admission rule and Chapter 33 can't live in harmony together. They are polar opposites, diametrically.
Hey, we're back. Talking tort reform. Fuck 'em out.
Opposed. So that is how we continue down the path of putting the responsible party, any evidence of cause of crash or collision goes before the jury in phase one. This bill will change that. And we will have that contradiction of Chapter 33 that you cannot ignore by this legislative body for one industry.
All right.
I'm happy to answer questions.
All right. Thank you, Laura. The chair calls Craig Island. Craig, I've got you here on behalf of yourself. And you put Texas Trial Lawyers, but I assume you mean Texas Trial Lawyers Association?
Yes.
Do I have your permission to correct that?
Yes.
So you're here on behalf of yourself and the Texas Trial Lawyers Association against the bill. Is that correct?
Yes.
Thank you. Go ahead.
Craig Island, Texas Trial Lawyers Association. Thank you, Mr. Chair and members. First, I have a rhetorical question for you, which is, I believe that the people here in this room know that without the addition of the Lucio Amendment, there would be no House Bill 19 from 2021 because the votes weren't there. Once the amendment
Well,
was-
Craig, we don't know that.
I would submit to you that the reason the Lucio Amendment went on was because both sides knew that the votes were not there.
I will submit to you that you could be wrong about that. Continue
Okay.
your testimony.
Yep. In Senate this morning, there was some clarification of the way the bill is written, to which I expressed concerns to you and others on the panel yesterday. And that is because there is in 554A, we now say there is no exceptions, and in B, there is no exceptions. And the whole subchapter is there is no exceptions. And even though F, which was mentioned previously, is mentioned, it appeared, the way the bill is drafted, that you could not submit a company in the first phase of the trial. And I believe that we committed to both Senator Birdwell in the hearing this morning, and we'll commit to you. Chairman needs to make sure that we get your language, which we believe clears that up, to make sure that that's not an issue. One thing I do want to make sure, it was said that a majority of the states have adopted the admission rule. And we want to talk about insurance rates. I have a list I will give to you that shows that 16 states have adopted the admission rule and 30 states have rejected it. And most of those states that have not adopted the admission rule is because they are compared to fault states. And the two don't work together unless you make exceptions and adjustments. Also, Mr. Chairman, you said yesterday that you wanted to know about any insurance impact. This same information I'm going to give you shows that there's virtually no difference between the admission rule states and the non-admission rule states. There's less than 3% difference in the aggregate of those. So I think it was talked about in the first panel that don't do this for insurance rates. Don't do this and say it's going to lower anybody's insurance rates, because the evidence shows us that's not true.
Okay. Thank you, Craig. The chair calls Jack Walker. Jack, I have you here on behalf of. Well, you got it correct. The others did not. I have you here as Jack Walker on behalf of the Texas Trial Lawyers Association and yourself registered against the bill. Is that correct?
That's correct.
Thank you.
Thank
Go
you,
ahead.
Mr. Chairman, Madam Vice Chair. My name is Jack Walker. I am the president of the Texas Trial Lawyers Association. I'm here to testify today in opposition to House Bill 4688, the trucking bill. Vice Chair, you said something earlier that we need to keep in mind as it gives context as we move forward. Texas is the deadliest state in the country for trucking accidents. That's where we should start. Now, what I think you're going to hear today, and what this bill is based upon, even based upon what Mr. Blanchard and Ms. Lucio talked about, is insurance. There's a myth out there, and these bills are always based on the same myth, that lawsuits and runaway jury verdicts are the cause of skyrocketing insurance premiums. You heard from Mr. Blanchard talking about his insurance going up and Mr. Lucio's insurance going up. This is a fear-based narrative that's brought out. It's trotted out every time we get one of these bills. But I want to talk to you about the insurance industry. And those of you that are on insurance know this because you've been studying it. But the insurance industry is making massive profits. In 2024, the property and casualty insurance industry made $169 billion. 90% increase from what it was in 23, which was $89 billion. Okay, I'll say that again. That's an 89% increase. And you'll hear anecdotal stories today about folks who have trucking companies and having trouble paying their insurance. Everybody in this room is having insurance issues, but it's not caused by lawsuits. It's caused by Uri. It's caused by climate change. The cost to repair vehicles has risen 20% over the last 2 years because all of our vehicles are now moving computers. We have cameras all around. If you have a little fender bender, it costs so much more to repair your vehicle. We've got higher medical costs. So I will conclude because I know I'm out of time. 30 years, we have 30 years of data that shows that tort reform does not lower insurance rates. What we need to be doing is not focusing on bills like this with a fear tactic of that it is going to lower insurance rates. We need to focus on the insurance industry itself. We need to focus on requiring rate review requirements, requiring transparency. Look at the industry that's making all the money, and don't focus on.
Okay, Jack, I'm going to ask a question before we go to Jim. Do I hear you right that you're criticizing, maybe that's too strong of a word, but you're casting aspersions at the profits that the insurance companies are bringing in?
Profits are great, okay? Profits are fine. That's what businesses are are in for. But they control the premiums. If they're making $169 billion, but they continue to raise premiums, I think that needs to be looked into, Chairman.
Yeah,
and
I think the profits that the plaintiffs' law firms that specialize in trucking accidents are making also needs to be looked into. We ought to look into both.
This bill is and the focus of this bill doesn't affect that.
All right, Jim Perdue, I've got you here on behalf of yourself and the Texas Trial Lawyers Association
He's such a punk.
testifying again.
Such a punk. You want to work in a law firm profits.
Trial Lawyers Association.
What are you talking about, dude? You're so bought and paid for.
I was president in 2021 and was honored to work with Chairman Leach on this bill. Worked with Chairman Leach, Representative Moody, and Representative Lucio about the amendment for which the current bill, which is in front of you, is attempting to essentially strip out of the law. Let me answer some of the questions that have been posed by the panel because Representative Flores, for example, you asked about more evidence-based testimony as opposed to what we just heard. Has there been enough time for this bill to work? They cannot identify for you a single case that has been affected by trial. There is one published opinion on this law, Chairman. It came out in December 2024 out of the First Court of Appeals, and it says exactly what you intended, what Chairman Moody intended, and that is that a plaintiff cannot attempt to offer irrelevant punitive damage evidence in phase one. That is the single appellate opinion on the bill. In other words, the bill works as written. One opinion in 3 years. I will tell you the other ramification of what I just heard from the prior, and it answers one of your questions, Representative LaHood. In a comparative fault state, the second question, I know Representative Schofield knows this, in any negligence case, ask the jury to ascribe percentages to all of the parties. I have a case in which one of the law firms that testified before, I have a lady sitting at a red light and she is hit from behind by a truck. And there is a claim of comparative fault on the plaintiff. So that when that case goes to trial and question 2 is asked, the question will be the liability under this scenario that they repeal the bill, the driver, not the company that knew they had a driver who was abusing marijuana and had never been trained a single day on how to drive a 25,000-pound vehicle, and the plaintiff. And so they would hide from the jury the company's responsibility for having an impaired driver who had never been trained and ask the jury to put 50% on a driver who was sitting at a red light, thus reducing the compensatory damages that can be recovered out of a phase one. That is designed to reduce fair justice. It may be the same number, Mr. Chairman, but the way the percentages work when you don't acknowledge the responsibility of the company is designed to reduce the accountability. And that's the problem with this particular bill.
Vice Chair Johnson.
Thank you. I know you said there's one published opinion, but do we actually know how many cases have been able to work their way through the court right now that have been under the new process?
Vice Chairman Johnson, I've spoken on this particular law, I think 5 different times now at legal seminars in the last 4 years. I have been on panels with defense lawyers in each of those speeches. And they have been asked, are you invoking the bill? And you'll hear from a former defense lawyer talking about the scenarios where this bill would get invoked or not get invoked. There are very real reasons why a good defense lawyer or a good company would not invoke this bifurcation because, as you've heard, you cannot insure punitive damages. So if you've got a company with 5 power units that's running transit vans, the insurance lawyer who represents the client can't counsel the client, I want to invoke bifurcation, but I'm going to move your risk I'm going to move your risk into phase 2 for an uncovered claim. And so there's reasons why it's invoked. There's good reasons, one big rigs. And let's be clear, this amendment and now the bill today only affects large power unit tractor trailer trucks. It does, the codification of these sections of the Code of Federal Regulations and the Texas Transportation Code for intrastate trucks is talking about rigs over 27,000 pounds. So you're not talking about delivery vans. You're not talking about mom and pop plumbing shops. You're only talking about the biggest rigs on the road that are subject to the list within 054C.
Jim, in that case you just mentioned, though, isn't that a gross negligence claim, not just a simple negligence claim?
It would be pushed into a gross negligence claim if the company stipulates that it has a driver, but you had evidence, if you had evidence, of some company policy that had been in violation. Because the proposition, right, is that they want to say all of the evidence regarding the company moves into the second phase, but the element of damages for the second phase is punitives. So
But in that case, the lawyer, the plaintiff would have evidence, unless I've misheard the hypothetical you were just talking about with the case, is you've got a driver that's driving without any training whatsoever, and
that's, yes.
so you're going to bring a gross negligence claim against the driver and the company. The company's driving in the course and scope. That's not a simple negligence claim.
And interestingly, in that case, Chairman, what they did is they bifurcated the punitive damages under Chapter 41, but they didn't bifurcate the liability question because they don't want to move the evidence of the company out of Phase 1. The question of punitive damages would be analyzed separately. That's current law. But they don't want to have the question of essentially the distortion of taking the company's negligence and moving it into an uncovered claim. Essentially what you would be doing if you were the defense lawyer in that situation is taking evidence regarding the company that would be involved in a covered claim, that is compensatory damages, and forcing it into a model where you're punitive damages. I would rather have it a covered claim. And believe it or not, a lot of defense lawyers would too.
Okay. Go ahead, Vice Chair.
Well, you lost me.
And I'm trying.
I'm sorry.
I'm trying.
This is
And
this
fortunately,
is
there's
not.
some witnesses, I think, that can address it a lot better on insurance towers and coverage.
And feel free, the panel's now, so feel
Yeah.
free to jump in. All of you are.
Yeah, and I guess I feel like Speaker Moody, my practice area is really outside of this zone, and this is something unique. I recognize the questions about insurance and looking at insurance. I also recognize you've got billboard lawyers and commercial lawyers that are talking about how they make billions and billions of dollars, and so you can see why the public is saying, what the heck is going on? But I do not want to put us in a position where we are keeping a jury from hearing evidence on bad actors.
That's my question about this case that Jim just referenced is the jury hears all of that evidence. In the hypothetical you just mentioned, the jury hears everything. Tell me how this bill keeps that evidence out.
If they were to stipulate that driver, what the proposition is, if we stipulate that driver is our driver, and he ran in the back of a lady at a red light, the evidence of knowledge.
Drivers at fault and companies at fault, both acting together with the proximate cause of the injury.
And
All the evidence comes in. And to use Lee Parsley's words, you can go for, a bajillion dollars in damage.
The problem, respectfully, that's exactly what 054A, when you read it, is preventing. It prevents me from introducing that evidence. That this is the fix that we would be more than happy to engage with, because if the intent is that type of evidence should come in Phase 1, then if we can fix 054A, we can clarify that that's the law. And if that's what Mr. Parsley says is the law, that's great. But when you read 054A, that would prevent the admission of that evidence regarding the company in Phase 1.
On an ordinary negligence claim.
Exactly. Exactly. That's my concern.
You're bringing a gross negligence claim in that case.
Well, you would have a secondary gross negligence claim.
I just don't see how the evidence stays out. I'm sure.
For punitive damages, which again puts you in the situation of a different measure with unanimous jury and an uncovered claim.
Mr. Chairman, while you're open on that, I just want to point one thing that we have not addressed, and that is the bill purports to apply this change in law to pending cases. And we don't do that unless there's some extreme issue, like on the sexual assault stuff. So please, when you take a look,
I agree with that. We'll
Yeah.
change that.
You nodded your head when we were having that discussion, and I didn't know if you had something to add to that question about whether or not this was going to keep out some of the evidence that we would traditionally expect a jury to want to hear in that.
Right. So the current law, Chapter 72, that passed in 2021, married admission rule and Chapter 33 because it created exceptions, right? And so our mandate was, you all need to work on a good policy together that protects good companies, protects the families that have been or suffered human harm, and hold the bad actors accountable. That's what came together for Chapter 72. Once you carve out the exceptions, then you're left with, there's foreign trucking companies, because we've got reciprocity CDL license with Mexico and Canada. They can come here. The case that I started a trial on, the driver didn't speak English. He had a Mexican CDL. You don't know what kind of training they undergo. They can come here legally because of trade agreements. And his tire detreaded, or he had a blowout. And the carcass of the tire went into the motoring public and people got injured. Okay, and so the company had knowledge that, we don't know if he could read his post-trip inspection or pre-trip inspection to check the tires. The company had knowledge that they were using retreading or retreaded tires as opposed to replacing tires, and they can, as long as they meet special requirements, such as a licensed manufacturer has to retread the tire. You can't do it in-house, right? So when you're looking at the conduct of the driver, that's one thing. You're looking at the conduct of the company, that's something else. So if that driver had 5 DWIs, 3 convictions of reckless driving or speeding, right? So that's on the driver, yes. But before that day of the crash, when the company gave the keys to the driver, that company knowledge is what comes in under the exceptions. The guidelines for the judges, because they didn't have anything set other than this conflict of authority, was if the plaintiff doesn't have proof that the company violated a standard or regulation and that violation was a cause of the crash, the company's not on the jury charge. They don't even get to gross. They don't even start the trial. That's how we were working up these cases under Chapter 72, because you're going to protect the guys that are doing it right. Say, yeah, maybe he had 5 DWIs. He had convictions. They were 20 years ago. You know, we hired him, we trained him, we did everything right. But if that's not the case, and they violated an industry standard or a governmental regulation by putting an unqualified driver on the road, that evidence should come into the first phase, because that is what's going to, the jury's going to determine the percentage of fault, and that affects the compensatory damages. Has little to do with punitives.
And we keep calling this the trucking bill. Again, could you just, because I was looking at the definition of what the commercial motor vehicle is, how limited is this particular statutory provision, and how limited of a potential defendant are we talking about in these provisions?
It covers every commercial motor vehicle. Every company that is furthering their course of business and is making a profit, that is a commercial motor vehicle. So it could be Juan Gonzalez's landscaping company, or it could be Southwestern Transport at 18-wheelers. It covers everybody.
So it's not limited to just 18-wheelers?
It's not.
It applies to school buses.
Thank you.
Also, landscape companies with magnets on the side of the car. I mean, this applies to essentially every commercial vehicle. It's not for personal use. Yep. Representative Hood.
Thank you, Chairman. So, just the way my brain works, I try to tell myself, like we tell our juries, right, don't let bias, prejudice, sympathy. I'm just trying to go off words, law, and what it says. So, what exactly does proximate cause mean? Or, yeah, what does proximate cause mean? It's a question.
Yeah. Okay. It's got to be a substantial factor in the cause of the crash.
So it's not but for, it's just a factor. Like, was there a number on the
Well,
factor?
there's got to be foreseeability, and it has to be the cause and fact of the crash.
Yes.
It's got 2 components to it. So if it's foreseeable, if you put a driver who has 5 DWIs, 3 speeding convictions, falsifies his logs, then you are in violation, company is in violation of the federal regulations, of industry standards to put that person on the road, and the jury should see that evidence.
So, and I wish I would have asked TLR the same question. I'm kind of processing. So, I do mostly criminal defense. I won't be embarrassed if you correct me if I'm wrong. At the most simplest thing, I think of this as like a relevance 404B bias prejudice situation, okay? And I don't know where to go, because on one hand, like in a criminal case, right, someone has bad record that probably is relevant to it, but its relevance is so prejudicial that the defendant would be convicted without even having a fair trial, right? And there are situations where we limit that out. And I think this is the inverse, right? Like, y'all want, I mean, let's be blunt, y'all want this in because it's going to help you win a case. They don't want it in because it helps them lose a case. And for me, the balancing act is what is in the best interest of justice. I care about people on a personal level, but analyzing the law, I don't care how much money the insurance company makes or the other factors. I'm trying to focus on the law itself. So, on page 1, subsection B, I guess, line 16, if an employer defendant stipulates in accordance with subsection A and the trial is bifurcated. So, is this thing on still? Did you come on, Mike? Does this only apply to a bifurcation case? Okay. So, I want to go back. I keep focusing on 1961 or Patterson, or y'all keep mentioning 72, 33. All that stuff is gibberish to me. But what I want to know is this, is is all this stuff coming from a respondent superior, like common law, at least in theory, originally?
I'm a little confused at what your
So
question is.
to hold a company liable for their employer,
Yes, it is responding superior.
okay. And so in the common law, under respondeat superior, was it just the person? Was it the person and the employer? Like, did the common law say, yeah, I'm gonna talk about them, but it's still you? Like, what did common law do?
Without a stipulation, if you have it's a fact issue. Okay, you go to trial and you say, I'm suing this person, but I'm also suing you because you're responsible for them if they were your employee acting within the course and scope of your employment. So in that situation, the employer might say that he wasn't working in his course and scope. It's a fact finding. Jury says, yeah, he was your employee and he was in the course and scope, so you're responsible. That's how respondeat superior works. Okay. But
And Representative Hayes' question is getting at the edge of where you are, which is there's situations where it's solely the driver, there's situations where it's solely the company, and there may be situations where it's a combination of both. And the common law recognized that. The common law recognized the responsibility for a driver, the common law recognized the duty of the company, and the common law, as before and after the codification of Chapter 33, recognized there are situations where there may be both.
As I look at C, I mean, some of the stuff makes sense to me, to cut out, like, was subject for an out-of-service order. I mean, that doesn't seem to go to liability or negligence, is more of a technicality, kind of like what Justice Blacklock said on the terminations. Medically certified is physically qualified. I mean, I guess my question is this, is what is so special about in C that has to be in C for justice to be served? I don't see it. And sorry, I'm being vague. What is so special about 72.054 subsection C? Because I'm guessing the frustration, D. I had it backwards. Let's go down D. If a civil action is bifurcated, evidence admissible under subsection C is admissible in the first phase of trial only to prove ordinary negligent entrustment. So D cites the C, and C is a list of stuff. So what? How is removing that changing the question of was the driver the cause of the accident?
Let me answer that for you with a hypothetical, okay? So you have a driver, and you have a company, and you have a plaintiff, 3 people. And in that situation, plaintiff is stopped and gets rear-ended by the driver. But the facts come out that driver was over hours, was drunk, and was told his employer, I'm tired, I can't go any further. And the employer said, you got to deliver that load, and you got to deliver it now. And the driver said, I'm not going to, you have to do it. So he continues driving. Okay? And you get into that case, and the jury's going to ask, let me finish.
Hold on,
Yeah.
but it'll help me out if, can you give me an example that's not super extreme?
Well, the only reason I'm doing that.
Yeah.
The only reason I'm doing that is because these are real facts, okay?
I get it, but what I'm trying to figure out, like, this is dealing with the, but the first phase, thank you, the first phase of it. And so, again, I want to be unbiased, and I'm prejudiced.
Right.
Take your time. You're doing great. We're tracking with you. And if
But-
we could limit the responses and the comments from the audience, the chairman would greatly appreciate it.
I want to know, like give me a middle of the road example so that I can visually see how these things are changed, how it affects it negatively. Does that make sense?
Right, but the middle of the road example won't. There are times when it would work. This is a time where it won't work because in that situation, if you were to ask the jury who caused that accident, what would the response be under that? It would be, well, it sounds like the driver, but it also sounds like the company. Because in that second question, they're going to have to apportion the negligence. Okay, they're going to be asked how much for other people that could have caused this accident, what percentage of negligence did they cause that lead up to 100%? If you leave the company out, which this bill does, then when they get to that question, they're going to say 40% on the driver, but where's that other 60% going to go? Do we put it on the plaintiff? You know, and what if there's another party involved? So it's because you don't apportion. This doesn't allow you to apportion the negligence of those approximate causes. I'll go back to something that Mr. Lucio said, and I wrote it down. He said, if it's a proximate cause of the accident, it won't be excluded in phase 1. This bill does it. That's what we're talking about today. That's exactly what we're talking about. If it's a proximate cause of the accident, it should never be excluded from phase 1 because the jury has to apportion the negligence. And if you exclude it, then it doesn't have anything to do with the damages, Chairman. If it's a $100,000 case and those are the compensatory damages, what it does is it's going to reduce the amount that the responsible party owes, especially if you have multiple parties.
Well, walk me through, Jack, the logistics of, in that hypothetical you just mentioned, is the driver the only defendant in the lawsuit at the time?
Well, in that situation, but you've hit on something because that's very rarely in these major accidents you just have driver, company, defendant, and then everybody crosses over.
So the company, let's just say there's a one trucking company that owned the truck, maintained the truck, received the call from the driver that said, I can't drive, I'm falling asleep, and the trucking company said, no, you got to deliver the shipment.
Yeah.
You're going to have that evidence, and you're going to sue both the driver and the company.
Yes.
Okay. So in the first phase of the trial, the company stipulates course and scope, and you're saying that at no point the jury's going to hear evidence in the first phase of that phone call?
Well, in that situation, they're not going to get to apportion the appropriate amount of negligence. Okay, it can have and so you're not going to hold the proper party responsible. It goes back to if it was a proximate cause. I would think everybody would agree here if the dispatcher was on there saying you deliver that load, drunk, high, I don't care. That's going to be some proximate cause, a percentage. If it's 2%, if it's 40%. If you exclude that evidence, there's a question they're going to get to that they're not going to be able to apportion that. It's going to be at loss because you've hidden it from them. That's why they don't marry. That's what Laura was saying a minute ago. This marries that the way it is now.
And so to Speaker Moody's point, you're saying that if this bill were to pass, that the evidence of that phone call would not come in the first phase.
Right.
Defendant driver wouldn't bring the company in?
Defendant driver.
Name the defendant driver's not gonna at some point gonna, I mean, walk me through how this works logistically. Defendant driver at some point's not gonna say, whoa, I'm not 100% at fault, I was forced to do this.
Yeah, the defendant driver, he would like to say that. It's kept out though. This excludes the evidence. Okay, they're going to say you can't pull any of that evidence in because that goes to negligent entrustment, not through the fact that you slammed into the back of the vehicle. Okay, that's what this says. That's what the bill says, and that's what we're trying to point out. Is it excludes? I'm going to go back to it. It excludes if something is approximate cause. It has to be heard, so that under Chapter 33, comparative negligence, it can be apportioned, and it does. It will never be apportioned. And it gets even more confusing when you have multiple parties. Because if you have multiple parties, then you're also going to have the multiple parties saying that. You're going to have the contractor company that if it was a construction zone, they're going to say, hey, wait a minute, I want to get that evidence in that the company, that phone call was made. But under this, the way this statute's read is that goes to negligent entrustment. That's out. You can't introduce the evidence. And so you
And going back to I'm confusing myself talking in circles here, but at some point there's not gonna be asserted in that first phase a gross negligence claim against the employer defendant.
whether you assume a negligence or gross negligence, you don't know, because under that situation, if I'm going to file a lawsuit, I'm going to assume for negligence and I'm going to assume for gross negligence. Okay, and I'm going to. But the gross negligence is under Chapter 71, what was it, 41, okay, which is, they'll bifurcate that, but that's a different bifurcation scheme.
But the gross negligence of the company, of the dispatcher, whoever it might be, the gross negligence of the company, you're saying that evidence of the company's gross negligence, the jury is not going to hear?
No, I'm gonna say that's negligent. Okay, Chairman. All right, I'm gonna go to the jury. I'm gonna say that was negligent. We'll determine if it's gross negligence later, because that's clear and convincing evidence, and that's got to be unanimous. I want to get this evidence in, at least that is a breach of the standard of care. That they breached a duty to the motor public. Okay, so that's the negligence, and I get to apportion that under Texas law, under Chapter 33, which is comparative. I get to apportion that so that the jury can say, okay, that employer's is 60%, and the driver's 20%, and or 60 and 40, because the plaintiff was sitting there, dead stop.
Representative Flores.
Because that's for compensatory damages, correct?
It is.
The gross negligence would be raised when you're trying to prove punitive damages. So that's later, that's phase 2. The phase 1, they're saying for the comparative compensatory damages, you want to make sure that all the evidence is in there so you can attribute the proportions that each party had in order to know if the plaintiff was responsible for some of it, if the driver was responsible for some of it, if the company was, and then it's percentages. So that's how you figure out, what the damages will be and which party is responsible for which, correct?
Correct. And if you had a multi-party crash where you had the defendant driver, the company, the plaintiff, and you had another company, and you pull the defendant company out, that jury has to get to 100%. That's what the instruction is. You pull them out, and if they're 40% and you pull them out, then the company escapes accountability of 40% of whatever the compensatory are. Non-punitive, but whatever the compensatory are, they are not held accountable for that. And if it's even $1, it's not fair. But if it's 20%, 40%, then you've got a scheme here that doesn't work, because you don't get compensatory. If it is a proximate cause of the accident, it has to be in phase 1.
Representative Hood, I think I interrupted you. Were you still?
You did, but now my brain's going, if someone else can go first.
I'm sorry, I didn't mean to interrupt. I was trying to be Representative Gonzalez and then Chairman Dutton.
Okay, so I'm looking at here the background and purpose. It says that this bill is aimed to curb abusive trial practices. What can you guys tell us what other legal tools or procedures are currently available to limit that right now in practice? And do you think this bill does just that?
If somebody files a frivolous lawsuit, which hurts all the good lawsuits, and we're all against frivolous lawsuits, there are tools. Rule 9, sanctions for frivolous pleadings. Rule 13 for sanctions. You can countersue for fraud. You can send an offer of settlement, and they end up paying costs and attorney's fees. There's a lot of tools in the toolkits for defense lawyers to file against those who are filing frivolous lawsuits. And many of those have been utilized. that we've heard about. They end up in reprimands many times of lawyers, so you can turn somebody in for filing frivolous lawsuits.
And the rules of evidence still apply, right? So all the evidence has to be relevant, and it has to be admissible to one of the causes of action in one of the parties. So there's that too.
You see, I have a few more. I'm looking at my notes because some of these have already been answered. As a commercial carrier, don't they owe a higher duty to the public? Can you kind of talk about that? Because I know some folks aren't trial lawyers. I've been trying to case it a long time, but just explain like the duty between a commercial carrier versus just the everyday person on the road. What is that duty and how is it different?
Well, so to qualify for the mandate that is the part of the bill that's getting repealed, or would be repealed by this bill, you're talking about vehicles that exceed a certain curb weight and require a commercial driver's license for the driver. A commercial driver's license is a specific license that has certain requirements, and it does come with it, like a professional license, a duty of care commensurate with a professional license. That's the law. What we were trying to do with this section and with this amendment, which was negotiated by the parties and accepted by the author, was to take that higher standard as it exists in the law, in the Code of Federal Regulations and the Texas Transportation Code, and identify those responsibilities of somebody with a commercial driver's license and a company operating motor vehicles with people with commercial licenses, and take that duty. And that's exactly what Representative Lucio said when we laid out the amendment, is balancing the interests by tying it, by posting it, as he said, to the federal regulations so it was an identifiable standard of care. There would be no dispute about what the issue was, and which would always be causative. And so that's where the list came from, literally the standard of care as it exists in the law. The theory, again, being people who are violating the law won't get the protection of the bill. People who are following the law will not have any problem with the amendment because there's no evidence of violation.
Do you believe that by not being allowed to present certain evidence in the first phase of trial undermine that duty somehow?
Well, I think that's been the essence of, I don't want to be repetitive, Representative Gonzalez, but that's the whole balance here was to try to address comparative fault and how we got to a resolution on that.
Can you tell us the purpose behind why a jury would award punitive damages? And what it's meant to
I think Laura's the better trial lawyer on this panel. She ought to answer that question.
So gross negligence is very specialized, and that is, first of all, you got to prove by clear and convincing evidence as opposed to preponderance of the evidence, or more likely. So it's a much higher burden for the plaintiff, and the jury has to be unanimous, whereas with negligence, the jury can be 10-2, that's in 10-2 to equal 12, that's in the Constitution, right? But on the gross negligent aspect of it, that is to punish for gross negligent conduct, right? There's got to be an objective and subjective knowledge on the part of the company for the gross negligence. Putting an unfit driver on the road would be a company that is not acting as a reasonably prudent company under the same or similar circumstances. That's negligence. That's not gross negligence. So the punitive damages then are capped at 2 times the economics plus $750,000, and they will buy you an appeal in every case, because whomever the winner or the loser is going to appeal that case. All that does is extend litigation for the parties. The plaintiff doesn't win, the defendant company doesn't win, the insurance gets to hold on to their money a little bit longer until it goes through the Court of Appeals, goes to the Texas Supreme Court, and comes back down.
I would just add, the talk about punitive damages is really irrelevant because nobody ever recovers punitive damages on appeal, period. I mean, show me any cases in the last 20 years that have affirmed a punitive damage award and somebody's paid it.
But I mean, if the whole point, right, is, I mean, it's obviously a higher burden, right, to be able to get a jury to award those damages. But even then, if they do, it's to discourage other people from these same acts or omissions, right? And so, does this undermine that? I mean, is that going to, I guess, disincentivize trucking companies from doing what they have to do because they're not going to maybe get popped with with punitive damages in phase 2 of the trial?
Right. I think what this bill does is it makes even the good companies go through a gross negligence phase of the trial.
Okay.
Instead of keeping guardrails there in for the judge, if we don't have proof of violation, if you don't have proof of cause of the crash, that company's gone. This waits until, let's see, was the driver negligent at all? If the driver was negligent, company goes into gross negligence. So that is not the purpose of punitive damages. It's just to have a second phase where a company will live.
Okay. And then just one last question. I know my Lulu over here has some questions. But I know that just as a trial lawyer myself, and then after COVID, and there's a lot of cases out there that people wait years and years to get their day in court. And we can all agree that there's always going to be bad actors out there, but we don't want to punish the good actors. The good actors are the folks who are genuinely injured, right, and will be affected for the rest of their lives. How, in practice, how does this limit you from giving your client the client who's hurt, right, or lost a family member, or what have you, their fair day in court? How does that affect your ability to be able to do that if this were to pass? Not everyone at once.
Well, yeah, I can answer. It goes back to what I was the hypothetical I was giving. You have a situation where you can't get true comparative, you can't get the evidence in to hold the right party accountable, and in that situation, then they escape accountability, and that's what it is because you can't get, again, if it's a proximate cause, it should be in phase 1, and if it's kept out of phase 1, then there's a failure of accountability.
Thank you.
Thank you, Mr. Chairman. You may have said this already, but But the way I understand this is, the admissions rule really collides with the comparative fault rule. And as a result of that, it makes the whole issue of comparative fault somewhat bastardized because you don't get the complete fault in that first phase. And what happens is, if somehow or another they didn't find at least a 51% against the person remaining in the first phase, you wouldn't have a lawsuit at all, would you?
That is correct.
That is correct.
All right, thank you, Mr. Chairman.
Representative Hood.
Thank you, Chairman. All right, what is an ordinary negligence claim, quote unquote? Like, is responding superior an ordinary negligence claim? Is a
I believe that the language in the statute, in the bill that you're referring to, is to make sure that there's no confusion with a punitive claim.
Yes, but so, I mean, I'm not trying to trick you, I'm trying to figure this out. So, and I'm just collectively or colloquially calling anything involving an employer a responding superior. I might be wrong on that, but, so my question is an ordinary negligence claim basically any tort action? I mean, like, any negligence tort, so like, responding superior. So this is, and I was asking my colleagues, so the proposed amendment, or bill, what the term is, would repeal C, D, and E, but it leaves F. And F says, nothing in this section prevents a claimant from pursuing, one, an ordinary negligence claim against an employer defendant for a claim such as, so it's not just that, such as negligent maintenance that does not require a finding of negligence by the employee as a prerequisite to an employer defendant being found negligent for its conduct or omission, or from presenting evidence on that claim in the first phase of a bifurcated trial. So I'm kind of, I mean, y'all are smarter than me, TL are smarter than me. I'm confused because why are we fighting to take this out when F is staying there? And F, the way I read it, says all this stuff can come in, maybe not a blanket list, but you can still bring in evidence against the employer in, I mean, it's still in statute. And then it says, or a claim for exemplary damages under, I guess, Chapter 41, for a more serious the gross negligence in a bifurcated trial.
So Representative Hood, you're absolutely, actually really smart because you've nailed the issue with our concerns regarding the bill and the amendment. Because you go back to the effect of what this bill does on A. Now, I thought you were reading from A. A says a civil action under this subchapter, that is 054, an employer defendant's liability for damages caused by the ordinary negligence of a person operating the vehicle shall be based only on respondeat superior. So yes, you are correct. F says what it says, but according to A, if that employer defendant has stipulated that the driver is negligent, you can offer the evidence, but it's a road to nowhere because you cannot submit the company's negligence. So there's ordinary negligence of the driver and there's ordinary negligence of the company. And if they stipulate, the ordinary negligence of the employer defendant cannot be submitted. And there's a cleanup that's available to us on this section. This is exactly what we talked about in Senate hearing this morning. If that is not the intent, if there's acknowledgement that F lives as an independent responsibility that gives rise to a cause of action for negligence against the company, then we can fix that.
Well, I mean, and again, I don't know intent. I'm just going off, I mean, I read it as an ordinary negligence claim against the employer for a claim such as negligent maintenance. Okay. So,
and I hope it's not the intent. I think that we talked about the language in F during the process of passing 21 is recognizing it was an independent responsibility of the company. And there's also been an acknowledgement that the exceptions in 053 create an independent responsibility of the company. If those live on, and Representative Lucio's words, that if it is a proximate cause of the crash for which the company has independent responsibility gets presented in phase 1, we can fix it. But the problem is the way A is rewritten by this amendment, that is the bill itself, we have concerns that the stripping of it gets in conflict with comparative and puts you into a situation where that evidence may be admissible, but it is a road to nothing.
all right. Representative Dyson.
I'll give it a try. So in A, what y'all were just talking about, A deals with damages caused by the ordinary negligence of a person operating the commercial vehicle. F deals with negligence not related to the operation of the vehicle, but something else that an employer did, right? So they're not really in conflict with each other. It's a different claim. It's based on something that the employer did that set up a proximate cause, maybe of the accident, not necessarily based on how the driver was driving whatsoever.
Well,
right?
It's always the operation of the motor vehicle. That's how the crash occurred. I think you'll hear from somebody, for example, there was no brakes on a dump truck, right? But it's the operation of the motor vehicle that causes the crash. It's just the proximate cause of the crash is the condition of the repair of the vehicle. But you have to have somebody driving the car.
Right. But the whole point on F is it's not the cause of action related to the actual driving of the car, based on the negligence of the driver of the car. And it says not based on the negligence of the driver of the car, because that's what A deals with, right? Or the truck.
In
this
concept.
case.
In concept.
Right. So to me, in F, if you have something like a negligent maintenance claim, you could put that evidence in along with A in phase 1 of the trial, right?
Everybody that we've had read it that is not as clear. And if that is the intent, it would be simple to clarify that that's the effect.
Okay, it seems, all right, and I guess maybe we can discuss that. Then let's go to comparative negligence part. Now, on A, what we're talking about is going back to the driver, right? And it's based off negligence of the driver has caused negligent driving, whatever. I think you used the example of the rear end, whatever, right? So let's stick with a truck rear-ending a car. Now, if the employer admits respondent superior, right, under this statute,
Yes.
then the way the statute's worded, and I guess the way the bill goes, you would not introduce evidence of what the employer's actions were outside of that.
Right.
If you're based on that.
Yes.
I don't understand how that changes the comparative negligence, because aren't you essentially merging the master and the agent, the employer and the employee, together about the negligence of the car wreck and the operation of the motor vehicle?
Well, you're not, and it really comes into play if we add one more defendant. Let's just add one more defendant, okay?
Okay.
Say there's, that you're stopped in your construction zone, okay? And so when the plaintiff sues the defendant and the defendant company says, wait a minute, they were not flagging that construction zone right. So you have those defendants there, right? So what happens? You've got, the facts are, if you're drunk, high, I can't drive anymore, you got to deliver that load. There's an approximate cause. Everybody could agree that dispatcher telling that driver to do that is a proximate cause. All right. Now you've got the defendant driver failed to apply their brakes. That's probably a proximate cause. Now you've got they're improperly flagging the construction zone, should have been stopped anyway. That's a proximate cause. Okay. But under this bill, you're gonna when you get to it, you're gonna look at the construction company, and you're gonna look at the driver. But you're not gonna be able to look at that conduct of them telling that driver to do it. And let's say that's 30%, 30%, 33, 33, 33. Okay. So you pull that out. All right. Then the jury they have to get to 100. Okay? So they're going to go, okay, well, we're going to go 50 and 50. So the construction company's going to get 20% of the responsibility that they're not accountable for, and the company's going to escape 30% of their accountability. All right? And the construction company's going to pay their extra part. Does that make sense? And that's why, because you've got to have, if it's a proximate cause, it has to be in phase one, so that the comparative can get to that 100% and they can apportion it appropriately.
The examples we talked about, negligent maintenance, the loading example, the call from the dispatcher, the directive from the dispatcher, driver calls and says, I'm tired, don't want to drive anymore, need a break. They say, no, you got to keep going. It is my intent as the author of the bill that if employer defendant takes an independent act separate of simply handing the keys of the vehicle to the driver, that should be included in the first phase.
And I would be honored to work with the chairman to try to fix it.
Then let's dismiss you as a panel and y'all go work on language and bring it back to me.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you. Members, other questions? Oh, okay, thank you. Okay. If y'all could just give me just a sec, we're rebooting our system of witnesses. Here, if there's, and we're just Sedania, and Gibbs, and
Correct, Your Honor. Conservative Republican who believes in the Constitution, including the Seventh Amendment, which was drafted by James Madison.
well, I'm a conservative Republican too, and I'm for the bill, so go ahead.
Okay, if I can get my time back. The day after you filed this bill, Chairman, as you know, as you likely know, there were 5 people killed in Austin at Palmer Lane and I-35. And that handout that I just gave you gives a good explanation as to why I'm opposed to this bill. James Madison wanted jurors to hear all the facts, and this bill would keep jurors hearing from all the facts. Some of the facts of what happened the day after you filed this bill, when those 5 people were killed on I-35 at Palmer Lane, they were killed by an Ethiopian man who had a driver's license for 4 days. The video that I sent you a link for on this handout shows that he clearly did not speak English. That is against federal and Texas law for him not to speak English while he's driving a motor vehicle. That's important, not because we're racist or xenophobic, but because he needs to be able to read signs, digital LED signs that are over our highways, signs that say things like road construction ahead, stopped traffic ahead. And there's an example of those signs there on the first page. Because I'm short on time, the second page of this arrest affidavit, he was arrested for intoxication manslaughter. It was determined later that there were no drugs, no alcohol in his system. He was simply fatigued. His hours of service log shows that he was consistently over his hours of service in the 4 months that he served for his employer. His employer was obligated by federal and state law to look at those hours of service logs. But under your bill, the jury would never hear about that because neither of those are approximate cause. He claims that this collision was caused by some phantom vehicle that cut him off. This bill is akin to telling the U.S. Attorney's Office that when they prosecute that terrorist who ran over people on Bourbon Street on New Year's Eve this year, they couldn't discuss ISIS, they couldn't discuss Islamic extremism because that is all irrelevant to what he did when he ran down Bourbon Street in his pickup truck. I would love to field some of the questions that the last panel fielded, because I think you got some incorrect or some inadequate answers to your questions.
Okay. If members have questions, we can wrap up the panel. We can come back around. Robert McCart, I have you here on behalf of yourself testifying against the bill. Is that correct?
That is correct. I am Robert McCart. Spoke against this in 21, so it's deja vu all over again. I'm not going to bore you with the story of our family tragedies. Not going to talk about the sordid history of the driver. I'm kind of simple. I find it hard to understand how introducing another level in the trial process helps me or anybody in this room. We spoke about that in the Senate this morning. While sitting here, I kind of had an epiphany. It dawned on me, it doesn't make any difference. I'm sure the bill was written with good intention. You can vote either way. It doesn't make any difference. You're not changing a thing. You've done nothing for all of these people. You're doing nothing for the next batch of people in a year or two that are going to be here. We're treating a symptom, not a disease. The best thing to do, the best that you can do, is you don't have the damn wreck to start with. Put your energy and money into the front end. Do something with these rogue drivers. Do something about the 70% of the trucks that fail a simple test with the DPS. Stop that. It stops the accidents. It saves all of this time and money and shattered families. And oh, by the way, the insurance company's money. Now, it's very hard for me to be real excited about insurance companies. As one of the state senators said this morning, the insurance company never loses. So, there you go.
All right. Chair calls Lysandra Cedeno. I have you on behalf of yourself testifying against the bill. Is that correct?
That is correct.
Go ahead.
My name is Lysandra Cedeno, and I'm from Dallas, Texas. I passed out a summary, or is going to be passed out, regarding my mom's case and her involvement in a 18-wheeler crash. So my mom was driving on I-10 when an 18-wheeler hit her from behind. Due to the accident, she suffered permanent brain damage and now requires to live in a facility for the rest of her life. The significance of her damages basically ended up being that she's going to need medical care for the rest of her life, and that is going to equate to $17 million to cover that care. The trucking company's insurance policy was only set to $1 million, so it doesn't even come near to the damages done to my mom. Just kind of talk about a little bit of the accident. It was identified that 3 out of the 4 brakes on the truck trailer were out of spec, and that the driver was on the phone for almost 6 hours, like 5 hours and 52 minutes out of the 6 hours and 35 minutes that he was driving on the day of the accident, which was allowed by the company. So they were allowed to be on their phones. Just to give an overview of her life before, she was just a remarkable, strong, independent woman that was a role model to not just us as her kids, but also to her community. And she was just a true advocate for those that needed a voice, and I know she'd be really proud of us for coming here and coming in front of y'all to speak our case. But now her life is just different, very, very different. Our life switched in a day, just from being cared for and loved by her mother to now having to take care of her, and she is fully dependent on other people for not only her care, but also her safety. As you can see, it's already pretty emotional. It's been 6 years, and it still hurts from the first day. So thank you for your time.
Okay. Thank you. Thank you for your testimony. I'm sorry to hear and read about this story, and we do appreciate you being here testifying. The chair calls Lysandra Cedeno. I have you on behalf of yourself testifying against the bill. Is that correct?
Yes, that's correct.
Go ahead.
My name is Julie Zandra. I'm from San Antonio, and I am opposed of the House Bill 4688. My sister Lysandra did speak about my mom's accident, and I just want to share our experience and our hurt, and I really apologize for getting emotional. I'm the youngest out of my 2 sisters, Cassie and Lily, and I was really close to my mom, and she's my best friend, and it is really hard for me to really not think about her and in my everyday life. And right now, I'm getting married, and I don't get to share that with my mom. And now we have to figure out how to even get her here, as there's always complications with her, and have her be present at the wedding. For my sister Cassie, I know she misses, and she speaks about all the time how she can't ask my mom for advice, or we can't call her for advice, or when something's happened, or something's good happened.